Honors, and may it please the Court. Alex Carver of the Nashville Bar for the appellants. With the Court's permission, I will reserve 3 minutes for rebuttal.
All right, 3 minutes. You may proceed.
Thank you, Your Honor. The trial court awarded the plaintiffs nearly $70,000 in attorney's fees in this case. That award must be reversed for 2 reasons. First, the award violates the American rule and is not authorized by the Uniform Fraudulent Transfer Act. And second, the plaintiffs lost their status as creditors under the UFTA, and with it their statutory standing to sue the moment my clients satisfied the original circuit court judgment in full. The court should reverse for both reasons. I'll start with the American rule. That rule says that a party may not recover attorney's fees unless a statute or contract clearly authorizes their recovery or some other exception to the American rule applies. The trial court awarded attorney's fees here under a provision of the UFTA that allows a court to award a creditor equitable remedies like an injunction, a receivership, or 3, any other relief the circumstances may require, subject to applicable principles of equity. That provision says nothing about attorney's fees, and it certainly does not contain the clear language required by Cracker Barrel and many other Tennessee cases applying the American rule. Instead, this case is just like Anderson versus Lowry from this court, where a trial court awarded a judgment creditor attorney's fees incurred in litigation to set aside a fraudulent conveyance, and this court reversed, citing the American rule. Although other states, like New York and Texas, have added provisions to their UFTAs that expressly authorize awards of attorney's fees in cases like this one, Tennessee has not. That alone is sufficient to reverse the award of attorney's fees in this case. Plaintiffs recognize that the American rule is squarely against them, so they've shifted gears on appeal and now argue that the independent tort theory, an exception to the American rule, allows them to recover their attorney's fees as damages in this case. But the plaintiffs' late-breaking theory cannot salvage their judgment for 3 different reasons. First, the UFTA's catch-all provision does not authorize awards of damages at all, so it can't authorize the recovery of attorney's fees as damages. Second, even if the UFTA did authorize damages, the independent tort theory only allows you to recover attorney's fees you incurred litigating with a third party, not the defendant. And that's not what the fees awarded here are broader than that. And then third, the plaintiffs waived the independent tort theory below. I'll address each of those arguments in greater detail now. The first and most critical point is that before the independent tort theory can authorize an award of attorney's fees as damages, a party must bring a tort law claim that authorizes it to recover damages at all. The plaintiffs did not bring such a claim in this case. Instead, they brought a statutory claim under the UFTA, a statute that nowhere authorizes judgment creditors to recover money damages in excess of their underlying judgment. Without a cause of action that authorizes the recovery of any damages, you can't recover attorney's fees as part of damages. Unlike in this case, every one of the independent tort theory cases that the plaintiffs cite and rely on involved a cause of action that authorized an award of damages. That was true in HT Tech Partners versus Crawford, in King versus Chase, in Whitelaw versus Brooks, and in Pullman. All of them involved tort law causes of action where a plaintiff could expressly recover damages. Here, in contrast, the UFTA's catch-all provision does not authorize damages at all, and three principles of statutory interpretation compel that conclusion. First, under the canon of iustum generis, the phrase other relief at the end of the catch-all provision refers only to other equitable relief. That phrase comes at the end of a list of remedies a creditor may obtain in a fraudulent transfer action. The list says that, subject to applicable principles of equity, a court may award a creditor, 1, an injunction against further disposition of property, 2, the appointment of a receiver to take charge of property, or 3, any other relief the circumstances may require. That phrase, other relief, has to be read in light of what precedes it. Just like the phrase, or the list, fishing rods, nets, hooks, sinkers, bobbers, and other equipment refers only to fishing equipment, the phrase other relief at the end of a list of equitable remedies similarly encompasses only equitable relief. The single best case I've read on this issue is the 11th Circuit's recent decision from last year in SE Property Holdings versus Welch, which explains why the UFTA's catch-all provision doesn't authorize either damages or attorney's fees. I strongly commend that decision to the court. I think you will find it very well reasoned and persuasive. Another reason that we know the catch-all provision doesn't authorize damages is that the General Assembly knew how to authorize damages for judgment creditors in the UFTA when it wanted to do so. If you turn the statutory page to the very next section of the UFTA, which is Section 309, Section 309B authorizes awards of damages for judgment creditors, but it puts limits on those damages. The award can only be against a transferee, not transferors, and the damages are capped at the amount necessary to satisfy the creditor's original underlying judgment. Because the UFTA expressly authorizes damages in the amounts and under the circumstances specified in 309B, you shouldn't read the catch-all provision in 308 to allow you to recover damages in excess of what's allowed in the very next provision. Third, the entire structure and purpose of Tennessee's UFTA confirms that it does not authorize damages in excess of the underlying judgment for a creditor. If you look at Section 308 of the UFTA, which is titled Remedies of Creditors, and you look at every single remedy it discusses, all of them are aimed at allowing a creditor to satisfy its original underlying judgment. The remedies listed in Section 308 are things like an attachment of property, levying execution on property, voiding transfers of property, enjoining further disposition of property, appointing a receiver to take charge of property. These provisions are set out at pages 19 through 20 of our reply brief, but none of them allows a creditor to recover damages above and beyond the amount of its judgment. The only other provision of the UFTA that the plaintiffs invoke is the savings clause, which is in Section 311. But that clause just says that the common law survives the adoption of the UFTA unless it's displaced by the UFTA. That provision doesn't raise up entirely new causes of action for damages that didn't exist at common law. And the plaintiffs didn't bring and haven't identified any pre-existing common law cause of action that would entitle them to recover damages, including attorney's fees as damages. So for all these reasons, the UFTA just simply does not authorize either attorney's fees or damages by which you could try to recover attorney's fees under the independent tort theory. But let's assume for a moment that I'm wrong about that and that the statute somehow does authorize this relief. Even if that were true, the independent tort theory still could not apply here for a simple reason. The thing that distinguishes the independent tort theory from classic fee shifting against the party you're litigating against is that you're only allowed to recover attorney's fees under the independent tort theory that you incurred litigating against a third party, someone other than the defendant that you're seeking to recover the fees from. Well, in this case, the $70,000 award of attorney's fees includes lots of fees that were incurred litigating against my clients here on appeal. $30,000 of the fees were incurred litigating against Dwight Holland, seeking to have his bankruptcy case dismissed. Others of the fees were incurred against LD Consulting and LAH LLC defendants in this very case. That's clear from Trial Exhibit 2, which are the fee invoices. It's in Volume 13 of the technical record. And I think it's also important to note that even if you thought that the independent tort theory applied, that would only conceivably authorize fees that were incurred litigating against third parties who were not found liable under the UFTA. So that would be the Dominion Real Estate entity or Jeffrey Holland and his entities. But of course, all the claims that the plaintiffs brought against those parties were uniformly unsuccessful. Dominion was dismissed on summary judgment. That ruling was affirmed by this court. Jeffrey Holland and his entities prevailed at trial. Those rulings haven't been challenged on appeal. And there's no reason to have my clients compensate the plaintiffs for bringing meritless claims against those other parties. Finally, that brings us to the third reason the independent tort theory cannot justify the trial court's award of attorney's fees, and that's that the plaintiffs waived this issue. There's a reason that Chancellor Lyle never mentioned the independent tort theory in her opinion, and that's because the only time it's mentioned before Chancellor Lyle is in one throwaway sentence at the end of the plaintiff's motion for a temporary injunction filed at the very beginning of the case years before trial. It's never mentioned again all the way through trial. And so it's no surprise that the plaintiffs therefore made no effort to distinguish between attorney's fees they incurred litigating against third parties, which might be recoverable under an independent tort theory if there were a damages cause of action, and attorney's fees incurred litigating against the defendants whom they're seeking to recover the fees from.
In the order granting the fees by chance or law, was there any mention of the independent tort theory?
No, it doesn't appear, neither do any cases addressing the independent tort theory.
And in her order, does she mention what claims were made in the second amended complaint?
She does. She mentions
And
the UFTA claim.
What were those claims?
It was a claim under the UFTA, count 1, and then civil conspiracy, which was count 2. And she addressed the civil conspiracy to violate the UFTA. So it was just a derivative claim of the UFTA. And she addressed those claims in her opinion, and she said that the catch-all provision in the phrase "any other circumstances, any other relief the circumstances may require," that's the provision that she relied on to award these attorneys' fees.
So she made the award under the Act, is that right?
That's correct. Under the Act, not under any common law tort claim, even unpled or unpled.
Okay.
I'll just say a brief word about the second argument we have, which is our statutory standing argument. The argument's pretty simple. The UFTA says only creditors can sue. It defines creditors as someone with a right to payment. The right to payment here was the circuit court judgment. That was satisfied fully, and you can think about this argument as either a statutory standing argument or a mootness argument. It doesn't change the analysis. The point is that either the moment it was satisfied, they lost their statutory standing to file their operative complaint the next day, or it mooted their existing UFTA claim. Both of those doctrines are jurisdictional. They have to be raised sua sponte by the court. That's in the footnote in our reply brief. And so it has to be considered if the court disagrees with us on the American rule. If you agree with us on the American rule, you don't have to reach the statutory standing and mootness arguments. But if you don't, I think that the court has to consider them because they're jurisdictional.
So in the second amended complaint, adding Mr. Holland, the judgment had already been paid, is that right?
That's correct.
Thank you.
Unless the court has any further questions, I'll reserve the balance for rebuttal. Thank you.
Excuse me. Good morning, may it please the court. Nicholas Bolso here for the plaintiff appellees, the Wise Group Inc. and the Lux Development Group LLC. I know the court has heard this before and may hear it every time somebody stands at this podium, but we have an important case for the court this morning because this morning the court is going to decide what remedies are available against a fraudulent transfer under Tennessee's codification of the Uniform Fraudulent Transfer Act. As the court has heard, the defendant appellants who engage in the fraudulent transfer at issue in this case are arguing that a defrauded creditor can only recover the amount of the underlying debt or judgment. In this case, it was a judgment, nothing else, nothing added to that. From the plaintiff's perspective, we don't see really any reason to tie the hands of Tennessee trial courts behind their backs when they're dealing with these sorts of fraudulent transfers, and that's especially true when aren't
we dealing with an act of the legislature, though?
We are, and that's especially true when we're dealing with that act because Section 66.308A3C has that very broad remedial provision that the court, subject to principles of equity, may award any other relief the circumstances may require. So a very, very broad provision authorizing the court to take whatever action is necessary.
But the act doesn't say anything about attorney's fees, does it?
It doesn't mention attorney's fees directly, Your Honor, no. And that's, we'll get into it because that's one of these issues that we keep batting back and forth between the appellants and the appellees is what exactly Chancellor Lyle awarded at the trial level.
Have you presented any authority in your brief that allows the recovery of attorney fees under that provision?
Well, there's a distinction we have to draw there, Your Honor, between attorney's fees as the prevailing party or attorney's fees recovered as damages. We get in, the appellants spent most of their initial brief arguing against awarding attorney's fees. And they deal with it very generically, just saying, they cite the Supreme Court saying if you're going to recover attorney's fees, the statute or contract has to be specific and very express. And that attaches when you are the prevailing party and you seek to recover your attorney's fees as the prevailing party. That is controlled by the American rule, which is what the Supreme Court is referencing. What we get into here, though, is that Chancellor Lyle never awarded us our attorney's fees as the prevailing parties. That follows from the procedural history of the case, and I'll try to dash through it as quickly as I can. But we had our case against Dwight Holland in the circuit court. We prevailed there. We obtained about a $35,000 judgment. We then sought to execute.
Did you request attorney's fees in that litigation?
We did not, Your Honor, and we didn't recover any attorney's fees from that litigation in the Chancery Court litigation.
Okay.
So we sought to execute that judgment and found out that during the pendency of that case, Mr. Holland had been transferring his assets to other entities and then moving any worthwhile asset he had to those entities and moving them kind of down a chain of fraudulent transfers, as we would allege. We discovered that. We went to sue Mr. Holland again and found out that he had filed a Chapter 12 of bankruptcy petition. And through the different mechanisms of bankruptcy law, we found out that because he had filed that bankruptcy case, the trustee had exclusive standing to pursue to pursue effectively our fraudulent transfer claims. And so the bankruptcy case cut off our ability to pursue those claims. We then had to enter the Chapter 12 bankruptcy case and argue that it should be dismissed and thrown out because, first of all, Mr. Holland was not a family farmer, and then there were other misrepresentations as to his assets in his petition. The court agreed with us, threw it out. We then went back to Chancellor Lyle, and that's when we pick up our second amended complaint. Everything prior to that, we had to leave Mr. Holland out because of his bankruptcy case. So we had proceeded against LD Consulting LLC, LAH LLC, Americana Birds and Bees, Jeffrey Holland, Tony Ruckerson, and Dominion Real Estate LLC.
Does the act allow attorney's fees against those other defendants?
We argue it does, Your Honor, and that's how we eventually get down to the independent tort theory. And I can kind of pick up a few other points there as well because...
But the act does specifically allow an award of attorney's fees in specific situations as to other specific defendants, correct?
Well, there again, Your Honor, I want to be kind of careful with how we answer that question because we keep just saying attorney's fees.
That's what I'm talking about, it's attorney's fees.
Attorney's fees as awarded to the prevailing party or attorney's fees recovered as monetary damages?
I'm talking about attorney's fees under the Uniform Fraudulent Conveyance Act.
As far as I know, there is no provision in the Uniform Fraudulent Transfer Act that mentions attorney's fees.
As far as even if there are different defendants not situated as your client is.
Again, it doesn't use that specific phrase, attorney's fees. It just, again, we get pushed back to that catch-all provision.
Okay.
So also, I understand that you're trying to argue that Chancellor Lyle granted you compensatory damages, not attorney fees. But I'm looking at her order, and it says the court awards attorney fees. Doesn't say anything about damages because of the fraudulent transfer. And then goes on to say, under these circumstances, the Uniform Fraudulent Transfer Act, subsection 3C, authorizes recovery of attorney fees. I mean, that's what she says. She doesn't talk about, quote, damages. She's talking about attorney fees. And she relies on the act. She doesn't rely on any independent tort claim. She's relying on the act. And you have no authority, Tennessee authorities, that says that this language in that code section, which doesn't say attorney fees, but talks about other remedies, and I think they are equitable, you don't have any authority to support this argument, do you?
Not from Tennessee, Your Honor. It's a matter of first impression here, which is why this case is important. I do want to go back to Chancellor Lyle's opinion, though. I can cite the court to the record. It's page 1202 of the record. This is a page where I presented to Chancellor Lyle all the authority I had on recovering attorney's fees as the prevailing party and recovering punitive damages under the catch-all provision. none of this actually ended up factoring into Chancellor Lyle's position or ruling, actually. You have to turn the page to page 1203, and that's where Chancellor Lyle references Hansard and Perfecta. That's the first is a case out of Florida, the second is a case out of Ohio. And that's where Chancellor Lyle wrote, the court concludes that under Tennessee law, monetary damages, including attorney's fees and expenses, are recoverable under section 66.3, 308A3C as any other relief the circumstances may require. And then she follows that up. And this is the basis for the plaintiff's recovery against defendants Dwight, Holland, and LD Consulting LLC. In the following paragraph, she goes and adds LAH LLC back into that. So Chancellor Lyle is focused on monetary damages.
And she did that in what order, what date?
This is her, it'll appear in both of her April 26th orders and her July 7th order. I'm referencing her July the 7th order. Record pages 1203 and 1204.
Well, where does it appear in her April 26th order?
It should be the same page of that order. It's on page 13 of that order. She only modified, I'm referencing her amended memorandum in order after we brought up the issue of bankruptcy fees. She brought that up again, and then her July the 7th order is almost identical except for the very last paragraph in the order.
I'm looking at page 13 of our April 26th order. I don't see anything like what you just suggested.
I'm afraid I don't have that order in front of me, Your Honor, so I can't point to it specifically, but in there, the paragraph starts from Hansard Construction Corporation. So Chancellor Lyle, again, is focused on monetary damages, and the question is, how do we get there? And so Chancellor Lyle relied on Hansard Corp. And Perfecta here. We have brought up also this issue of the independent tort theory. It's something we brought up with Chancellor Lyle one or two or three times. As the court can see from the record, our focus was really on recovering attorney's fees as the prevailing party and punitive damages. This argument we had about recovering monetary damages was kind of a follow-along argument that we were making just to preserve it. And then in this order, Chancellor Lyle actually focused on that to the exclusion of attorney's fees as the prevailing party and punitive damages. So that's the option she chose there. And it makes perfect sense that Chancellor Lyle would have done that because she had actually just handled a different case. It was the King v. Chase case where she had just referenced the independent tort theory. And that will clear up actually how she awarded us monetary damages and why that doesn't actually infringe on the American rule as the appellants are arguing.
But in King versus Chase, there was an indemnification provision as a part of the partnership agreement, and it was under that provision in the partnership agreement that provided for an award of attorney's fees because the partner or officer was acting for the benefit of the partnership and incurred fees in protecting partnership property. There was not an award under the Fraudulent Transfer Act of attorney fees because that didn't have anything to do with the King versus States case.
Well, that first part's not quite accurate, Your Honor. That was the first basis. So the court looked at that, and there was an indemnity provision in the LLC agreement. That was a dispute between the partners in a partnership that controlled the LLC. The first part was that the LLC was supposed to indemnify the successful counterclaimants, but the LLC didn't have assets to actually indemnify them. So the court went a step further. That's where the court said, well, because the LLC doesn't have assets, that's where Chancellor Lyle said, because the LLC doesn't have assets to indemnify them, you, the other partners who are not subject to that agreement, are going to indemnify them, and here's why. It's because of the independent tort theory. The plaintiffs there made a very similar argument to what we hear from the appellants here today, which is that even if we're going to call those attorney's fees damages, they can't be recovered because of the American rule. And what we learned in King v. Chase is that that's not the case. As a matter of fact, the Court of Appeals said there, here the Chase party's attorney's fees and costs were not awarded because they were the prevailing party in the litigation, which is what the American rule is designed to prevent. Rather, in this case, attorney's fees and costs were awarded to compensate the Chase parties for actions they were forced to take to defend the NV entities against the King's unilateral lawsuit. That's where the King case starts citing the Pullman v. Standard, which talks about the independent tort theory. And the court cited to Pullman in its explanation that when it appears to be well settled that the natural and approximate consequence of a tortious act of a defendant has been to involve plaintiff in litigation with a third person, reasonable compensation for attorney's fees incurred by the plaintiff in such action may be recovered as damages against the author of the tortious act, which is the independent tort theory. And so as we pointed out, the independent tort theory, this method of recovery, gets baked into the Uniform Fraudulent Transfer Act through Section 66.3.311, which incorporates into the Act every provision of common law that does not conflict with it. And so now that we have that imported into the Uniform Fraudulent Transfer Act, we have to bring up this issue of the American rule, which what the Court of Appeals said when they were reviewing Chancellor Lyle's position or her ruling in the King v. Chase case was that the American rule, however, simply prevents a prevailing litigant from collecting a reasonable attorney's fees from the loser, prevailing award to the prevailing party. The American rule does not apply to consequential damages flowing from a separate harm under Tennessee law. One who through the tort of another has been required to act in protection of his interest by bringing defending an action against a third person is entitled to recover reasonable compensation for loss of time, attorney's fees, and other expenditures thereby suffered or incurred in the earlier action. So that again is how we go from talking about this issue of attorney's fees to the prevailing party, and we realize that an award of monetary damages, especially when it's made pursuant to the independent tort theory, doesn't even implicate the American rule, because it's not a reward to a prevailing party, it's just compensatory damages. The defendants respond to all these points by arguing that the independent tort theory was waived. Again, it wasn't our focus before the trial court, but we did bring it up. We did argue before Chancellor Lyle, and she did cite to the Hanser and the McCullough cases in her opinion, so we don't think it's been waived. They argue that the independent tort theory is not applicable here because we didn't have a common law tort claim. Fraudulent transfer, of course, was a common law claim that then got codified to try to regularize how it is applied. They argue that they are not third parties, but they argue they were not third parties, they were transfers, not transferees, but they were transferees before they were transferers. And that is how we get from suing those entities and then recovering just those damages we incurred against those entities from Dwight, Holland, and some of the other ones. And then lastly, they bring up SE property holdings. We see a lot of issues that we bring up in our brief with the SE property holdings case. I would just point out that even if we follow it and we say that the catch-all provision is limited to equitable remedies, the independent tort theory, is a principle of equity. And that, again, is brought up in the King case citing that. So even if we go down that route, which we don't think the court should, that doesn't really affect the theory that we have advocated for the court and the theory that Chancellor Lyle adopted when she awarded us our monetary damages. And for all of those reasons, we're asking the court to reverse Chancellor Miles' orders and restore our full judgment to us.
Tell us again what claims you raised in your second amended complaint.
They were the fraudulent transfer, violation of the Fraudulent Transfer Act and civil conspiracy. We didn't bring the independent tort theory as a standalone claim because in our view it's not a standalone claim, it's a method of recovery.
Okay.
Thank you.
Thank you.
Your Honors, just a few brief points in rebuttal. Judge Armstrong, you asked about Tennessee authority that speaks to this issue. The most relevant case is Anderson versus Lowry. That was a case under the Fraudulent Conveyance Act, very similar to the Uniform Fraudulent Transfer Act. Like here, trial court awarded a judgment creditor who had to litigate to set aside a fraudulent conveyance, attorney's fees incurred in litigating to set aside the fraudulent conveyance. This court unanimously reversed. It's an unpublished decision, but it's very persuasive. There's also been a lot of discussion about whether Chancellor Lyle, called this attorney's fees or damages. I read the order the same way you did, Judge Armstrong, but I think ultimately it doesn't matter whether you use the label of attorney's fees or damages to describe the money that was awarded to the plaintiffs in this case, because the Tennessee Supreme Court has twice considered arguments where a plaintiff came into court and said, I would like to recover attorney's fees under a statute that allows me to recover damages. That was the Cultura case from the Tennessee Supreme Court, and in Cracker Barrel as well, there was discussion of one of this court's decisions called Burson that had allowed a plaintiff to recover attorney's fees as damages under a statute that said you can recover as damages any expenses incurred in enforcing the statute. And the Tennessee Supreme Court said in both Cultura and in Cracker Barrel, that language is not clear enough to authorize attorney's fees, even if you think of them as damages. So I don't think that the label, one way or the other, matters at the end of the day. There was a reference to the plaintiff's effort below to recover these attorney's fees as punitive damages, and I just wanted to make sure that the court is aware that there is published precedent from this court holding that it is inappropriate to award attorney's fees as punitive damages in Tennessee. That's Interimages Inc. versus Newman from this court in 2019, cited in our reply brief at page 16. And then the last point I'll make is that Mr. Bulso started, I think, with some policy concerns about whether or not it's fair that a judgment creditor may have to incur attorney's fees to collect a judgment. And I'd say two things about that. First, the judgment in this case was satisfied in full with interest 6 months to the day after it was entered, which is pretty good in the realm of judgment collection, as I'm sure all of us know from experience. When you collect a judgment, getting it paid in full 6 months later is pretty good. And the second thing I would say is that to the extent there is any policy concern about unfairness to judgment creditors who have to pay their own lawyers to collect a judgment, that concern can and has been remedied by legislative action in other states. New York and Texas have adopted provisions to address exactly that concern. The Tennessee legislature could do the same thing, it just hasn't. And so we're not trying to tie the court's hands, we're just trying to respect the General Assembly's judgment in the law as currently written. Thank you, Your Honor.
Thank you, counsel. We certainly appreciate your argument, your briefs. We'll take the matter under advisement and we'll render an opinion as quickly as we can. We're going to take just a brief recess, and while we're in recess, if you folks want to move to the appropriate tables, we'll get back in just a few moments and pick the case up.